2 weeks after the watchdog legislation was tabled in the Parliament, concerns are only growing as legal experts start to go through the detail of the bill. Now, chief among those concerns are the proposed changes to how warrants generally work in this country and just what sort of protection there will or won't be for people referred to the watchdog. It would seem the rules that usually apply about judicial oversight won't be applying here. Here was the Attorney-General at the National Press Club today.
It will be for the Independent Commission to determine whether it wishes to conduct some telecommunications surveillance or execute a search warrant on private premises, because the Commission won't need a warrant to walk into any government department. The legislation provides for it to have the power to do that and ask for documents. So we're talking about search warrants of private premises or telecommunications being conducted on anyone, because that will require a warrant. All the people who are charged, which might be judges and might be AAT members, all that they do in that function is to review for lawfulness. It's a very straightforward function.
Just following up on Crowy's question then, if all they do is review for lawfulness, does that mean that they're just going to automatically approve a Commissioner's request for a warrant, or do they actually have a job in reviewing the request for a warrant?
Everyone who issues warrants has a job to do.
Joining me now, legal affairs contributor at The Australian, Chris Merritt. Well, it's about as clear as mud, Chris, when you listen to the Attorney-General there today, and aside from the smirk on his face, he strikes me as more and more smarmy these days. I mean, this is tricky. People should be able to rely on the judicial protection of a warrant. That's about as fundamental as it goes in our legal system here in Australia. It looks like that may well be watered down or even diminished under this watchdog. Help everyone at home understand why this is such a concern.
Look, what we're going to lose, we'll definitely lose the ability of our politicians and community groups to speak freely to their politicians. There'll always be a risk now that a free, open discussion between politicians, particularly between politicians, could be monitored by the new agency. Some famous person once said that legislation is wonderful, but it's like sausages. You don't want to watch the process. And I think that's what's going to happen. The process of making laws and public policy will be subject to oversight by this agency. And on Mr Dreyfus's remarks at the National Press Club, what he didn't say was almost as interesting as what he did say. It was just last month that the Commonwealth Ombudsman issued a pretty damning report on the way law enforcement agencies are currently dealing with telecommunications interception, the requirements that they've got to live up to when they currently tap not telephones, but text messages and emails. There's been an upsurge in non-compliance by law enforcement agencies. So that's the standard that we're about to replicate. Mr Dreyfus's bill would give the National Anti-Corruption Commission the same provisions, the same rules, the same powers that are currently supposed to be upheld by all those other agencies, the ones that the Ombudsman criticise. So I'm a little bit worried that we're heading in that direction without first insisting on proper compliance by the other agencies. The other thing I'm a little worried about...
Let me just jump in though. Chris, let me jump in though on the point about the AAT being able to sign off warrants under the bill as it's drafted. The AAT members are not lawyers. The vast bulk of them are not. Right now, if you want a warrant into someone's home or to access their personal information, phones and emails and that sort of thing, it's generally before a judge, and there's a whole lot of obviously legal training that comes with that. Now, people might say, well, what then do you let anyone in the AAT decide? Well, they decide lots of administrative issues, and of course they're always subject to judicial review. There's a higher appellate structure to review their decisions. Once they give away a warrant under this model, they're in your home, they're through your house, they're through all your private communications, and that goes to the point you're making. This, I think, if it's that lax, is dangerous for democracy.
Look, it's worse than that, Peter. the bill makes it very clear that it won't be every judge and it won't be every member of the AAT. The bill would vest with the Attorney-General, the minister who will be the minister responsible for this, the power to pick and choose which judges and which members of the AAT have the authority to issue these warrants. Now, the potential for politicisation is enormous. If there's one thing that needs to be changed in this bill, it's that power. There's a very good argument that power should be subject to at least oversight and possibly joint control by the Oversight Committee of Parliament that's going to be looking after the NAC. It's too much power to be giving to one minister.
I tell you, when I was involved in drafting legislation for the rights of terrorists inside the Australian judicial system, warrants was a big topical issue. And would-be terrorist suspects in this country have, it would seem, more rights in relation to warrant oversight than what we're giving politicians, the head of our spy agencies and others. Chris Merritt, thank you.
Quite all right.